So John Moore has been NCRA's legal counsel for 20 years. He has a distinguished career in law, starting with teaching a first-year law course as a third-year law student and winning his first case at age 24. He's a board certified in civil trial law and has been named by the Chronicle as one of the best lawyers in San Francisco. He's here to present Winning is Not Everything.
So I learned from trying jury cases that if you want anybody to listen to you after 3 o'clock in the afternoon, you have to do something dramatic. The other dramatic thing I'm going to do is say, free alcohol and food. After the conference at 4:30, NCRA will have its annual Green Drinks. It'll host its annual Green Drinks affair. It will be the same place as last year at Spat's Bar at 1974 Shattuck. There will be catered food, and the first 100 conference attendees that come will get a free drink ticket. That's up from 50 last year, and some of you may remember Arthur Boone out of his own pocket taking 10 people for drinks afterwards. We've come a long way since then. So I'm here to talk about 3 local Bay Area lawsuits within the last year that are worth knowing about. Each one was challenging an action of a local government. It's not easy to do that. The law is stacked in favor of the governmental entities. The judges deferred to the governmental entities. In fact, judges are government employees. So it's not an easy thing. And when you take on the government, the expectation isn't necessarily that you're going to win, but that you're going to make a point that's important. So in that sense, winning isn't the only thing. So the 3 cases I'm going to talk about. First is Recycle for Change versus the City of Oakland. The city passed an ordinance regulating what they call unattended donation collection boxes. And the challenge, because there's not a lot of ways to challenge policy, the company challenged it based on the First Amendment, free speech right. The district court didn't like the argument, and the Ninth Circuit Court of Appeal didn't like the argument. The second case is one you may have heard about. It's the suit by Arthur Boone and Dr. Tony Stein against the Alameda County Waste Management Authority. And that case challenged whether the authority did an adequate CEQA review when they gave discretionary approval to Waste Management for its mixed waste processing project. That's the only issue. You may have heard it was about other things, but that's the only issue. And the third one is Premier Recycling against the City of Sunnyvale, which happens to be a case of mine, where there's a challenge to an exclusive franchise in the city, or rather the grant of it, because one, they didn't comply with the state law that requires certain findings be made before an exclusive can even be granted. And secondly, the idea of exclusive garbage franchises when applied to construction and demolition debris, which is what my client collects, we think is federally unconstitutional. And that's a cautionary tale from one of our Supreme Court justices. Now, I'm not going to be able to give a complete review of 3 cases in 10 minutes, so if there are things, there's more you want to know about them, or if you have questions about them, or you simply want to tell me I don't know what I'm talking about, those are the email addresses of the 2 co-chairs of our Zero Waste Advocacy Committee, and we encourage you also to join. The Black Knight I like to think of as NCRA because it never gives up, no matter how many limbs of it gets cut off. So again, the first case is the Recycle for Change versus the City of Oakland. It regulated these boxes. It was initiated by the planning department, and the planning department pitched it to council on the basis that this will help with blight, graffiti, messes around the boxes. Okay. And so the ordinance, when passed, states what its purpose is. And again, it says blight. Okay. Within the ordinance, it has zoning controls where you can put the boxes. It has cleanup obligations on the box owners. Those are perfectly fair exercises of police power. But the planning staff went one more step, and the council either didn't pick it up or didn't care, which is the effect of the ordinance is to effectively prohibit the placement of these boxes in the City of Oakland. And the way it does it is kind of insidious. There is a long statute requiring what's in the application. And one of the important things in the application process is the box owner, here Recycle for Change, has to find the property owner, not who's ever operating on the property, but the property owner, and get the property owners not only their consent to the box placement, but they agree to abide of all the laws relating to the box. Well, I'll tell you for sure, and I'm for sure about this, that there is no tenant that is going to go to their landlord and get a landlord's signature for that kind of consent. They're not going to care enough about the box to do that. So it effectively prohibits the placement of these boxes in the city. Just to give you an idea, this is the second page of the application requirements. And so how do I know that it had an impact? Well, we know from Recycle for Change. In the year before the ordinance passed, they recovered 300 tons of textiles from these boxes. In the year afterwards, they collected 69,000 tons, which translates to about 0.34 tons per year. So what happened to and I love this. Oh, it's supposed to flash. Well, anyway. What happened to the other 299 tons? Well, it probably wasn't Willie Brown's old suits that were going into the boxes. So it's fair to assume that they went into the garbage can or the recycling bin, and if we trust what Jeff Denby told us this morning, they might as well go to the landfill because they're so contaminated that they're worthless. And that's what happened here. And I have no idea if the city's recycling or zero waste people had any idea or input into this thing, but if they're here right now and they think it's wrong, they ought to go back to council and change it. The other case is, the next case is the Boone-Stein case, and it has to do with, first with the 2011 approval by the city of San Leandro of Waste Management's project at the time for its Davis Street transfer facility, and specifically those buildings over on the left-hand side, which at the time Waste Management was going to develop to a much more extensive composting and digesting system. And the city of San Leandro looked at the project. They did an initial study as required by NCRA, and the city concluded, well, there's not much of an impact on the environment from this, so we're going to issue a negative declaration. So then we skip ahead to 2017, and Waste Management now decides that they want, instead of what they had in 2011, have a mixed waste processing system. And so they go back to the Waste Management Authority because they need an approval for them. And the authority studies this and, again, makes the conclusion that, well, what's different about this is the mixed waste processing. And the authority ultimately concludes just what it says. There have been no changes to the project. Well, that's the issue before the court right now. In fact, as we speak, the Superior Court Judge McLaren is considering what to do in this particular case. She held a 2-hour oral argument 2 weeks ago, and that's the issue. It's the only issue. And I'm not going to make any opinion about that issue, being a Stop Waste Board member, but there is one thing I want to mention because it's come up a lot of times, and I'm disappointed in myself for not doing more with this. But we really didn't focus, I think, enough on the compost quality, the output of this mixed waste processing, because even though Waste Management said, oh, it's going to meet certification standards, I forget which one, but there's no permit condition requiring it. And now we're finding out from Europe that their experience with the compost quality is pretty lousy. And we heard Will Bax and a number of other speakers say today, crap in, crap out. And having bad quality compost is almost worse than having no compost because it stigmatizes the market. So I think that we need to be watching this as Waste Management goes further with this project. We need to pay close attention to the compost quality. The last case is the one against the city of Sunnyvale. Now, it is permissive for a city to grant an exclusive solid waste franchise. It's not mandatory. Some people think it's mandatory. It's not. It's permissive. And the only basis for the city to grant an exclusive is if it makes these findings, that the public health, safety, and so require. So you have to think, well, what about this stuff requires that only one person collect it? And so we make the case that historically, when garbage franchising first started, when municipalities started collecting the garbage, that that's what it looked like. 1900, we had bubonic plague epidemics in San Francisco in 1904. We had cholera, we had typhoid fever. People died because of accumulated garbage and what they attracted. And until the late 1800s, we didn't know that it was germs that were causing that. So all the solid waste laws come from this. And we say in this case that what was allowed to be regulated here under the police power is not the same as that. And we take some comfort into it because the US Supreme Court decided that a state Supreme Court decision, here the Rancho Mirage case that I'm sure you all know about, that a state Supreme Court decision can be unconstitutional as applied if it impairs property rights. And so Premier Recycling is saying, well, look, you know, this Rancho Mirage case that allowed a fee-for-service litmus test for whether something's solid waste or not, well, wait a minute. That impairs property rights. That shouldn't be allowed to stand. We didn't have any chance to argue to the court before. We want to argue to the court now. And this case is now in front of the Ninth Circuit, so we're going to be finding that out reasonably soon. The Rancho Mirage Supreme Court overturned an appellate decision in the same case. The appellate court found that the franchise system in the city of Rancho Mirage was in fact unconstitutional. And when it went to the state Supreme Court, the Supreme Court, the Supreme Court decided, well, we're not even going to consider the constitutional issue. So I think that issue is still ripe. And so we end with some of poetry's most inspiring words for the underdog that's fighting the good fight there without his arms and legs. And this is me. If you know any businesses that are in have terrible legal troubles involving lots and lots of money, have them call me. Thank you.